Hey guys, welcome back. Today we're talking about canceling escrow as a seller once you're in contract with a buyer on a property. I'm Jeb Smith, real estate broker here in Southern California, and I appreciate you taking the time to watch. Do me a favor, if you like this video, at the end, hit the subscribe button, hit the like button. More people will see it, which is my goal to help educate others out there through the buying and selling process. So, this isn't a question that often comes up. Typically, it comes up from the buyer side because the buyer gets into escrow and then they want to cancel for whatever reason. So rarely do you get into escrow, at least in my experience of 17 plus years, and the seller want to back out of the contract. So the question is, can you do it? And legally, contractually, the answer is no, you cannot do it unless for whatever reason you built some sort of contingency in there for finding a replacement property or something along those lines. So with regards to that, what I mean is that if you're a seller and you're selling your property contingent upon finding another property and you don't find that other property, absolutely, you can definitely back out. But if you just sign the California residential purchase agreement that a buyer, signs, just the typical RPA, and you sign it as a seller without any additional contingencies or anything changed in that contract, legally, contractually, you're not able to back out. Now, the buyer has contingencies on their side that they can use to back out, the appraisal, the loan. There's 6 different contingencies: appraisal, loan, HOA, if there is one, home inspection, seller disclosures, prelim, those items, right? So they can use those items to back out. But as the seller, once you get into escrow, contractually, you can't back out of that. And so that can present a problem. I've actually been in contract with a seller about a year ago who signed a contract to sell their property with a buyer. I was representing the seller on this transaction, and once they got into escrow, 24 hours in, buyer hadn't even put the money into the escrow account yet, and the seller wanted to cancel. Went back to the seller and said, you don't have a leg to stand on. You've signed this contract. And what happened is, if the buyer really wanted to enforce it, they could have gotten an attorney, they could have, sued for damages, whatever that would have been at that point is really hard to determine because they were only in escrow less than 24 hours. But at the end of the day, they had signed a contract to sell their property to these buyers. So the buyer was the correct one. I mean, they were right in this scenario. And so had they wanted to get an attorney, take it to court, they could have really forced the hand of the seller to either sell the property or pay some sort of fee for backing out of the contract. In this case, the sellers were nice enough after a couple of weeks to find a property and let the sellers out of the contract. The sellers moved on and what have you. So in that case, it actually worked out. But, as a buyer, if you're able to ask for requests for repairs, you're able to ask for these different things in the contract. And even though the seller disagrees with it, the seller can't just say, I don't like your request for repairs, I want you to cancel escrow, or I want out of the contract. That's not how it works. The buyer and seller can go back and forth on negotiation throughout the entire contract and not agree on really anything until they get to a sticking point, at which point, the seller can say, either move forward, perform, they can issue a notice to perform to move on. And if the buyer doesn't perform at that point, then the seller can back out. But as long as the buyer is, abiding by the contract, the dates within the contract, etc., the seller really can't back out of a contract. Now they can decide that they don't want to sell their house and really just not agree with anything, and have the option of going to court or going through arbitration mediation to try to figure it out. And if you can't figure it out through that process, then actually going to court, assuming that you sign the arbitration and mediation clauses. So, as a seller, make sure when you're selling your house contractually, when you sign that contract, that you're obligated to sell your property, because, these scenarios do come up. And they're not fun scenarios to deal with. I mean, things happen on buyer side, things happen on seller side, and life changes. But once you've signed that contract, it's a contract, right? It's the state of California. It's written to protect both buyers and sellers. But at the same time, you've got to abide by those. Otherwise, you're in violation of the contract. You could be sued for damages. You could be sued for the property to actually sell it. And in some cases, the court enforces that, right? They could come back and say, you have to sell your property based on the contract that you signed. So again, this is just, helpful information. If you're looking to sell a property and you signed a contract, or before you sign the contract, just make sure you know you want to sell. And as a buyer, once you're in contract, you have the option to back out of that contract, which I've done a video on that, and I'll link to it here. Where you can back out of the contract. But once you've released contingencies on that property, if you then back out of that property, your deposit's at risk. So just make sure that as a buyer, you understand what you're getting yourself into as well. But either way, I hope this video was helpful, answered your questions. I appreciate, again, you taking the time to watch, and we'll see you again soon. Have an awesome day. Bye-bye.